impermissible procedural requirement. And, you know, we think that there are just so many ways that this statute cannot apply in federal court.
Can I just ask you about one of them? Because getting back to Justice Barrett's question, I thought your sort of clearest, most narrow, direct conflict was with Rule 3. And I know that you mention it, but you really rely on 8 and 9 in ways that I don't know are necessary. I thought the theory was that we have this Delaware law saying what is necessary to file or initiate a malpractice lawsuit as a matter of procedure. You have to have this separate AOM. Notably, it's not evidence. It is just what is a necessary step to initiate this lawsuit. And under federal law, no such thing is required. The federal law says that the action commences by filing a complaint with the court. So why isn't that just clear, narrow, direct? It doesn't rely on any thoughts about factual versus legal. In fact, this is a factual distinction that could support a conflict, could it not?
Yes, Your Honor. I mean, we do assert that if there's a conflict with Rule 3, part of the reason is that the lower courts on our side of the circuit conflict have really looked to Rules 8 and 9 and seen that as the fundamental sort of site of the conflict with the federal rules of civil procedure.
It seems more complicated to me because it does require, it's sort of piggybacking on what Justice Sotomayor was saying. We're looking at what is legally sufficient in 8 and 9. And Justice Barrett points out that this is an affidavit, it's not a pleading. There are distinctions there that I think would allow for a credible argument that there is no conflict because we're talking about later stages and it's evidentiary and all of these things. Whereas this initial point, like what do you need for the clerk to accept your document and start this case, is different in these two different realms.
Yes, Your Honor. And we obviously agree wholeheartedly with that theory of the case, and it really is as simple as that syllogism.
Well, if that were right, if you're just relying on Rule 3, Delaware goes and changes its statute and says you have to file it 20 days later, right? Then you don't have Rule 3 anymore.
That is true. That is the narrowness of it is that you would only be addressing.
Yeah, I mean the fundamental thing, isn't it, is the entire thrust of the federal rules, most particularly in Rule 8 and 9, which is it was meant to establish a notice pleading system where all you had to do was to say, here I am, here's my claim, I'm going to be seeking damages, the end, and everything else was supposed to happen later in the normal course of things. And then a defendant had a bunch of different opportunities, starting with Rule 12, and then continuing on with Rule 56, summary judgment, or using summary judgment even pre-discovery in various circumstances to get rid of the suit. And that's basically the structure of the federal rules.
Yes, and I think that puts the finger right on why we put so much weight on 8 and 9. I mean, this statute, like the similar statutes, is fundamentally at odds with that notice pleading structure that the federal rules rely on. And it creates lots of problems in federal court to try to import these sorts of things because all the other federal rules are built on the foundation of notice pleading. And the idea that the suit starts with the submission simply of this paper that says your claim for relief, your statement of jurisdiction, and your demand.
Mr. Tutt,